So we can start now. Everything is ready. Eh? So, appellant side. Who are the appellants? Yes. Come and start. Yes, yes, you are allowed to. So speaker one will be Atul.
Yes.
Good.
Before proceed further, the council would like to object on the jurisdiction mentioned by the respondent, as their jurisdiction does not come under the ambit of this honorable court. They have come under section 154 of CRPC, which states information of cognizable offense. Yes. 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 Yes, Your Lordship.
Hello. So it's your appeal.
Hello. Your Lordship, I am putting objection on the respondent.
The objection will come subsequently. You should present your case. What is your appeal? You haven't told me that you are appellant.
Yes.
So appellant means that you are making an appeal before the court. What is your appeal?
To quash the FIR that was filed under section 482 of CRPC. Sushant. The council seeks permission to present the statement of facts. Indeed, Your Lordship. Ava is a young 18-year-old girl who pursued her studies from Hashu International College, Hastinapur. She was on a live-in relationship with her senior Tarun and got pregnant during their relationship. Ava's parents, who were initially unaware of her relationship, decided to get her married to Tarun. However, Tarun and his parents refused the marriage and alliance are accused of Abha of having illicit relation with some another man. Abha filed a petition for maintenance from Tarun in Tisajari court court based on their living relationship. Later, Abha's parents decided to get her married to Sushant, a 28-year-old law graduate who law graduate. The marriage proposal was accepted by Sushant's father. After discussing the matter truthfully, both Abha and Sushant went for a pre-wedding tour to understand each other. Their marriage got solemnized on 14th January 2021. Abha, who was already depressed, got further frustrated because her husband uses to only cohabit with her to fulfill his sexual lust, and there was no emotional bonding between them. On 28th January 2021, around 2 a.m., Abha found that her husband was physically involved with his past friend, which completely ruined their relationship. Afterwards, Abha, finding herself alone, and contacted Tarun, and both again started meeting each other. On 25th February 2021, Sushant saw Abha and Tarun leaving from a hotel room. Later that day, Sushant came home drunk and inquired Abha about her visit to a hotel, and both got into a heated argument. Sushant, in his inebriated condition, had forceful intercourse with Abha, which led to complete breakdown of their marriage. Later, Abha narrated the whole event to both her mother-in-law and was told by them to adjust herself and to remain silent. Abha's mother-in-law threatened her to remain at their mercy and physically hit by her. Feeling aggrieved, Abha left Sushant's home and started living alone in a rental accommodation and in Dekapur, in New Hastinapur. She filed a petition against Sushant for rape and also against her in-laws for domestic violence under Domestic Violence Act 2005. Abha's petition to claim maintenance from Tarun was dismissed by Chaudhary court on the ground that she was not legally wedded wife of Tarun. Against this decision, Abha filed an appeal before Hastinapur High Court on the ground that she is carrying Tarun's child in her womb, which is result of their living relationship. The council seeks permission to proceed with the issues raised. Indeed, your lordship. Issue number 1 and issue number 2 would be presenting by me, and issue number 3 and prayer would be presenting by my co-counsel. Issue number 1, whether the petition filed by Sushant under section 482 of CRPC for quashing FIA which was logged by Abha for committing rape is maintainable or not. On page number 10, para number 2, it is humbly submitted that Sushant has the knowledge of law, being a law graduate from University of Hastinapur, and in our knowledge, it is clearly stated that Abha herself wanted Sushant to get intimate with her. Due to lack of time, Sushant was unable to fulfill her sexual pleasure, and she used to complain him for not giving her time. It is submitted here that in an instance Sushant saw, here submitted we have so many instances in which it is clearly given that Abha wanted to leave Sushant and was willing to stay with Tarun, as she was in a touch with Tarun even after getting married. She used to share most of the things with him, and also they decided to meet at a hotel room. Tarun was showing his concern toward her. And later Sushant saw Tarun and Abha coming out from a hotel room, and he asked Abha for that meeting with Tarun, but Abha told nothing to him, and they both exchanged hot arguments. If we talk about section 9 of Hindu Marriage Act, that is restitution of conjugal rights. In this, it is clearly stated it's a duty to commit their marriage and to accompany their partner. Your lordship, the victim was always wanted to be in touch with her ex-boyfriend Tarun, as she met her ex-boyfriend before her marriage. When the petitioner and the respondent was in their pre-wedding tour, which was suspicious in the eyes of petitioner, showing that the respondent did not ever wanted to stay with petitioner, but because of her parents, she was not leaving Sushant. As Sushant, because of his profession, being the youngest member of parliament, also he had a lots of work and lesser amount of time to spend with his family, including his wife. But Abha refused to understand her husband's busy life schedule. As a result, she started talking to Tarun and getting feeling for him. She always has feeling for Tarun, and as she was carrying Tarun's child from their living relationship and Tarun and Abha, it is very clear that she could not move on from the feelings she had for Tarun and was wanting to find the ways to reside with Tarun again. As a result, the charge of rape against the petitioners are baseless. The petitioner believed she was content with their physical and emotional relationship because the respondent never prohibited any sort of sexual intercourse and never communicated to improve their emotional bonding. Your Lordship, the petitioner is a member of parliament as mentioned above. He owes some duty toward the voters of his constituency and the people of India in addition to duty towards her wife. But it would be pertinent to mention here that the defendant is very well aware of this fact at the time of inception of marriage. In the landmark case of Rita Nijavan versus Bala Kishan Nijavan, court may please refer to this case. Last page. Sorry. Okay. Marriage without sex is an anathema. Sex is the foundation of marriage. And without a vigorous and harmonious sexual activity, it would be impossible for any marriage to continue for a long time. It cannot be denied that the sexual activity in marriage has an extremely favorable influence on a woman's mind and body. The petitioner was not informed of the respondent's pregnancy. He couldn't demonstrate his concern and emotional support for his wife since he did not knew that she was pregnant. Without knowledge of respondent's pregnancy, petitioner was fulfilling his marriage commitment. If she had known, he would have undoubtedly taken good care of her wife and assisted her during her pregnancy. Sir, the relevance of this judgment is that for our valid marriage, and if you want to make your marriage successful, you have to cohabit, because without sexual life, your marriage cannot be go good with time. No, sir. Sir, because your Lordship, because in this judgment, in that paragraph, it was stated about the sexual pleasure which is relevant in our case.
That's true, but not applicable in your case because you're not seeking divorce. I believe you are comparing with Sushant.
Yes, indeed, your Lordship.
You want quashing of this FIR. That this FIR has been, wrongly lodged against you. Not sustainable. We can find ways to how the question came of divorce and sexual pleasure and all. Whether Sushant had got married with Abha.
Yes. No. It's all about the crushing of FIR.
I believe that you told us that Abha and Sushant they got married.
Yes.
So you could have made some judgment to have any judgment that in case the person is married. So in case of marriage, section 375 is not applicable. Only then you can survive. Otherwise, you don't have any case. Recently, you must have heard that in Delhi High Court, the argument for more than a month was continued that in case of the marital status, also 375 should be applicable. Judgment has not come, and rather the court has advised parliamentarians that to take the case and whether it is in case Sushant and Abha got married, right? So where is the question of section 375? Existing law of marriage.
Your Lordship.
So this FIR is baseless, not maintainable, it should be outrightly rejected. This is your argument. You are not relying upon this. Why? Where is your second speaker? What is that? Law, second speaker.
So she would be 3.
Actually, I got this. What he's saying that Sushant and Abha, they have been a good friend, had all relations.
No. Sushant and no. Sir, your Lordship, Sushant and Tarun, Abha and Tarun was in a relationship, and Sushant's family and Abha's family is a good family friend. They were not friends.
Then repeat the fact again.
Whole fact or this much?
Just explain to already what is the fact.
Abha is a young 18.
Three characters.
Yes, Abha. Okay.
One is Abha,
One is Tarun.
one is Tarun.
Abha and Tarun was in a relationship.
So,
Tarun, a relationship. And in that relation, she got pregnant.
she got pregnant with Tarun.
Yes. Later on, she filed a petition for maintenance, seeking for in a live-in relationship.
Okay.
Uh,
Son came in.
let me.
Son came in.
Abha. Can you repeat?
Abha got married
Married with Sushant.
son.
Yeah.
Then after delivering the child, or
No, she's still pregnant. She's still pregnant.
she is pregnant.
Yes.
So what is the question now?
The question is, Abha is putting allegation of rape on Sushant. Sushant is her husband. Yes.
That he committed rape.
Rape, marital rape. Yes.
Then you are asking that
Uh,
where not by
uh,
Abha
yes.
against the son,
Yes. For committing rape.
not
Yes.
so the this again question is because the son is something as right. The son case is that he is married with Abha. And if he is married, then he is married by cannot level allegation of rape. Under section 375, even though
Yes.
they had
Exception.
without consent, it cannot be a rape.
Yes.
Son, I think Abha has no son.
Yes. Your Lordship, we are in favor of Sushant that that marital rape is not a rape, and there is exception for Sushant that if
Yeah, I'm also talking the same thing. I'm also talking the same thing that there is an exception in 375.
yes,
But till date,
there is no law.
FIR of rape cannot survive against him. Married husband. Okay. So you have both the case, otherwise what is the problem?
Sir,
You have brought the IPC, have come to the exception only. Why are you talking about divorce and
Lordship, because it was Lordship, I was just referring the case that restriction of conjugal rights, that cohabitation is necessary
what for? Means
for marriage.
you want a question of FIR or you want
Yes, I want questioning of FIR.
FIR is filed already. What is the worry now?
Indeed, Your Lordship.
So ask the hearing figure to make some solution.
Indeed, Your Lordship.
Right.
My co-counsel would be presenting issue number 3 and prayer.
What is number 3?
Issue number 3 is Ava want maintenance from Sushant, from her husband, because she want to reside separately from her husband.
So she will talk about
Yes,
the maintenance
yes.
of Abha
Yes,
against son.
yes.
So let us listen what is three cases that are
3 cases, 3.
what are you asking for?
Okay. Prayer. Pass an order of quashing the FIR against petitioner, that is Sushant. Pass an order of maintenance in favor of Abha, the appellant, that is Abha. Sorry.
These are very good.
Yes.
Only talk about Why
Yes.
talk about Abha?
Yes. I'm talking about.
The council is afraid.
Nahin.
The council is on behalf of petitioner.
Sushant.
The second case, that is the second issue, where it is the Abha is, sorry, the Tarun is the petitioner. So we are on behalf
On
of
the,
Tarun.
Don't list everything at one time.
Your Lordship, in the first issue,
And also here to make you all understand that what actually the law is and how it is, right? You are student, so we are thinking that you are student, you have to understand, and being already professor, we have to make you understand. In case you are representing
Sushant.
so at one time, you have only talked about son, right?
Okay.
You cannot talk about Abha also, Tarun also.
I'm talking about Sushant only.
You talk about Sushant that the FIR lodged against illegally wedded married husband cannot be sustainable with the reason that the Abha is the wife
And even though admittedly, there had been occasion of sexual relationship without consent also, in that case, section 375 will not survive. So this court should quash this FIR lodged by Abha.
Abha.
Right? This
Yes.
one issue.
Yes.
So the other side will let to get ready that why this FIR should not be quashed. Right? So you have to take down, you have to very precise to the issue. So the second issue you are talking about,
That Abha is that Tarun is liable to pay maintenance to Abha. Second,
Tarun is
liable.
no.
Whether the Tarun
who
is
will
whether
represent Tarun?
They were representing. We are representing Abha.
So let them put their case of Tarun, then we will allow you to. Huh?
Second case, against they're appearing for other parties. There's a
Yes.
second
Huh.
case.
So no, I'll clear the confusion. So in case you will make any, contention on behalf of Tarun, then you have to raise your case on Tarun. We will distinguish it. It is our prerogative. It's not a matter of worry. So for Sushant, we are convinced that your case should be quashed,
We
right?
oblige your lordship.
So let the Tarun come, then we will decide about Tarun also,
Indeed, your
Huh?
lordship.
right? That will be much better.
Sorry.
You are representing Tarun?
No, I'm representing Abha, not Tarun. Yes.
You are?
Representing Abha, not Tarun. They are representing Tarun.
Acha, in the other issue, they will represent
Tarun.
Tarun and
And
you will
I-
represent Abha.
Abha.
So let us wait for a moment. Who will represent Abha from this side?
In FI, quashing of FIR case. You are
Yes,
representing
what's your good name? Himanshi, you come and clarify that first issue. You will all also learn what is the existing law today. So I have patience and listen it carefully. खड़े रहो, बैठे हो क्यों?
Sir, our issue one, whether the petitioner Sushant is to be tried for rape.
So yes, be very clear now. Repeat it again. The issue is that Abha, legally wedded wife of Sushant, she has lodged an FIR under section 375,
Indeed, Your
right? 376. When punishment section is 376, it is always invoked in 376. So your case is that yes, it is maintainable. Sushant must be prosecuted for section 376.
Indeed, Your Lordship.
Right? So you confine your argument to that extent only. Because we have come to know about the fact that Abha has got married with Sushant. Now you tell us that how this petition should be dismissed.
Indeed, Your Lordship. Firstly, in the recent Karnataka High Court recently Karnataka High Court in marital brutal rape case under the IPC section 375, 377 of Hirikesh Sahu versus State of Karnataka on March 23, 2022. It was held that the charge framed against the husband for alleged offences punishable under section 375 of IPC for alleged rape of his wife. In the pecuniary of this case does not warrant any interference. It is a matter for trial. This supports our case or Abha that we are saying that the honorable court should try Sushant as a rapist, and it should not consider it as a marital rape, but it should be tried for rape. And even in the writ petition by RIT Foundation and by All India Democratic Women's Association on marital rape being an offence under the consideration of Delhi High Court, who has reserved the judgment on this subject. Even marital rape is an offence. Marital rape is an violation of Article 14 and 21. Marital rape is which provide a dignified. Article 21 basically provide the dignified life, and marital rape goes beyond hurting a body and a soul to more beyond a dignity of a woman. And if it will be continued, then it might threat the life as well. As per the facts of the case, the respondent was subjected to marital rape, by which she was suffered unwanted intercourse during her pregnancy, which Sushant just did to satisfy her lust. Therefore, there is no sexual pleasure in the physical relationship, and Abha has suffered the physical and mental trauma. Therefore, we request the honorable court to try Sushant as a rape.
Very good answer. Actually, you are also well versed with the latest situation. So now what do you suggest that the arguments which are still going on in Delhi High Court, the law which is already in existence by statute, so whether that can have any effect at the present situation, because the existing law is that it cannot be a rape, right? My brother colleagues, they are also here. Still, it is not amended, right? So what do you say? That, there are few judgments, one by Karnataka and one by Chhattisgarh or some other court also, that has aired, the entire argument that why it should not be considered as rape. Even marital rape should be considered as rape. But still, I must apprise you that it is not rape till date. Okay? So you have argued very well. Thank you. बहुत अच्छा लगा. Now let us come to the second issue.
Sir, I would like the honorable court to be some clear about the facts. They are basically, in which you are getting confused. There are basically three different petitions in this memorial. And we are dealing.
No, we are not getting confused. We are very clear about it. We are clearing it one by one, right?
Okay, sir.
It was a case of Sushant that you are legally wedded wife, his legally wedded wife. You have labeled allegations of rape.
Yes,
It is not sustainable in the eyes of law. It should be quashed,
yes, sir.
right? So successfully he has been able to get resolved this issue, and this FIR will go as per the existing situation, right?
But sir, the honorable, we would, from the applicant side, from the respondent side, we would request the honorable court to kindly consider it as a rape, as it is a violation of Article 14 and 21 as well.
We'll think about it, but I think we three are of the same opinion that at present today, it's not a rape, right? You presented your case in a very good way.
Indeed,
Thank
Your
you. Sit
Lordship.
down.
Much obliged.
Thank you. So rebuttal, we have understood, but in case you have any legal issue, then you tell us that we should allow it as a rape, or what do you say?
No, your lordship.
We are saying that it's not allowed as rape.
Yes.
Then I don't think that you all, as a law student, you must understand. Every time rebuttal is not required. Every time rebuttal is not required. In case the law supports you, in case your argument supports, in case the respondent is not able to substantiate their case, then you need not to unnecessarily put some rebuttal. Why to? We have understood. Now let us come to the second issue. Who will represent that? Taruna, kya naam hai? Tarun.
My co-counsel will be representing
Yes,
the second and third.
please come.
Much obliged, Your Lordship.
So the legal history of this particular case is like this, that Abha was in relationship, live-in relationship, which with Tarun, it fell down from that relationship. Then Abha petitioned Tisajari District Court for maintenance under that relationship against Tarun, live-in partner. Tisajari Court quashed that particular case, saying that they are not husband and wife. So Abha went to High Court with the appeal that I may be given maintenance from Tarun. We are representing Tarun's side and saying that the district court judgment should be maintained.
What about Sushant? What do you say about Sushant?
वो third case है sir वो. उसको बोलूं?
No. The same Abha got married.
To Sushant.
The same Abha had relationship with Tarun. Subsequently, she got married with Sushant.
Sushant, yes sir.
So, you cannot ignore Sushant also.
Yeah. We are not ignoring Sushant. In fact,
Yes.
our logic is that. Sir.
No, it cannot be, because we have to talk about Tarun as well as Sushant also.
Absolutely.
Your claim, what I understood, that your claim against is that he had sexual relation with me. I conceived from Tarun, and subsequently I got married with Sushant.
That is Abha's.
Abha.
We are from Tarun side, sir.
You are for Tarun,
Tarun side. Sir.
only for Tarun.
Yes, sir.
So who is representing Abha?
They will represent Abha.
Council.
So let the Abha put her claim, that what is her claim.
Fine, sir.
Huh?
Fine, sir.
You say on behalf of Abha,
Yes.
what she is asking for?
Maintenance.
Yes, tell me, Abha is asking maintenance from whom?
From Tarun, from from her living relationship.
Acha. She is not talking about Sushant.
No, in this issue, she's not talking about Sushant.
You see, we cannot ignore this issue or that issue. You told me that
Abha, your lordship,
Abha-
Abha filed
Abha
two
was-
petitions.
relationship with Tarun,
Yes,
because they all will also understand. It's a very good proposition. Abha was in relationship with one Tarun.
yes,
She conceived a baby from Tarun,
yes,
right?
yes.
So after how much time she got married with Sushant?
Within a 1 month,
Within?
within a 1 month, after conceiving the baby in a 1 month, she got married.
She got married with Sushant.
Sushant.
But she is not asking maintenance from Sushant. She is asking maintenance from Tarun.
Your lordship, she already filed a petition before her marriage. She already filed a petition before her marriage from maintenance, for
Okay.
maintenance from Tarun.
Okay. So you tell us about Tarun.
No, I will tell you about Abha.
Oh, no, you will tell your allegation against Tarun.
Yes, yes. Proceed. The learned district court failed to appreciate the fact of the case and hence dismissing the maintenance appeal. The judge haven't considered the important fact of this case. She is carrying in womb the fetus which was the result of living relationship between Tarun and her. The judge failed to appreciate the statute of land, specifically the Protection of Domestic Violence Act 2005. The judge erred in terms of the protection of women from Domestic Violence Act by holding that only legally wedded wives are liable to get maintenance.
Do you have any judgment that even in case a lady is not legally wedded and she can get maintenance from the person with whom she was having a relationship?
No, Lordship.
There are many judgments. I do not know why you are not having.
Lordship, because in this case, later she got married, so that's why the
Even a mistress is also allowed to have maintenance from the gentleman. But you should have produced some judgments also along with your claim.
I was entitled to get maintenance in terms of living relationship. If we see essentials of living relationship, then she will be liable. She will be
Now
entitled.
the question arises that for what period she is asking for maintenance? Whether she is asking maintenance for the baby which she had conceived with Tarun, or she is asking for her maintenance also, despite the fact that she is already having one more husband, Sushant.
Your Lordship, it is not mentioned here anyway.
Why it is not mentioned here? You should have come along with the situation.
Not in the mood problem that she is she is seeking maintenance for her baby or for herself. So we are presuming it that she is seeking maintenance for her baby. Because Tarun is a biological father.
So who is representing Tarun?
Sir,
What do you say that Tarun is entitled to give maintenance or not?
sir. Tarun-
Admittedly, Tarun had a relationship with Abha.
Yeah.
Admittedly, she
Yes.
conceived with the baby of Tarun, right? So in that eventuality, whether you are entitled to pay maintenance to Abha or not, that is the question.
Yeah, your lordships, we humbly submit that Tarun is not liable to pay maintenance to Abha out of the live-in relationship because of certain reasons. One reason is that Abha is now married to someone else and she is the responsibility of someone else. That is number one
Do
reason.
you have any judgment or any statute which talks about this?
I'll come one by one, sir.
Please come.
I'll sir. The second thing is that even if there is a husband and wife gets remarried to someone else, Section 25(3) of Hindu Marriage Act, because they are all Hindus. Even then, in remarriage case, maintenance is cancelled or withdrawn as per Section 25(3) of that. That is the spirit of the law. Third point which I would like to point it out, sir, is there have been two judgments. One is the Indra Sharma versus VKV Sharma, and another was the D. Veluswamy versus D. Patta Chamalaya, like that. Both the judgments are based on the Section 114 of Evidence Act, presumption of marriage, which basically is again using the language of the Commonwealth marriage, which says if both the people are together for sufficient period of time, acting as husband and wife in the society, sharing the same household, sharing the expenses, having cohabitation and things like that, then they will be presumed to be husband and wife. So these are the judgments based on all these things. Sir, there are 2 points which are worth noting here. The guidelines, if we can say test or guidelines to these 2 cases, then 2 things are important. One is for a significant period of time, they should be together. And second is the legal age to marry. As my co-counsels have very rightly put, everything happened in 2021 very fast. Abha got into relationship, she got pregnant, she came out of that relationship, she got married, then she came out of that relationship also, she filed cases and all that. So this all happened very, very quickly. There was not enough time given to their relationship, live-in relationship between both of them. So we cannot say that their relationship has carried over a significant period of time. That is one point, which doesn't meet the test. Second test is the legal age. Abha is barely 18, no doubt about that. But the question is whether Tarun is 21 or not, because what is said in the Moot court proposition is Tarun is Abha's senior in the college. In the college, if someone is senior, then it is a bit difficult to presume that he might be of legal age to marry of 21. So there is a doubt, and from the circumstances, presumption can be taken that he cannot be of 21 years of age of
Now, I think now this issue requires rebuttal. You are talking about the rebuttal.
Yes.
So he is saying that, look, she got remarried, she got married with somebody. Since there was no reasonable time of staying her with Tarun.
Your Lordship,
And Sushant was actually liable to pay the maintenance. In rebuttal, what do you want to say?
Your Lordship, the petition was filed before the marriage of Abha. That's why Tarun is liable to pay maintenance to her.
Pardon?
Sir, petition was filed before Abha's marriage.
That's true. So are you asking for that particular period till the period when she is not getting married, or you are asking in perpetuity that for whole life? This ambiguity is there. It should have been clear now.
You
Huh?
have filed cases against both
Yes.
parties, against
Ah.
your living partner and husband as well.
So whatever proposition has been given, I am not much aware about that. But now the situation is, this fact is admitted.
Sir,
He
this
also
fact
admits
is
that he
clearly-
is my son, the baby is mine. So in that situation, what is your rebuttal? For actually, there is some problem in facts only. So let me clear you all. So maximum Abha can ask for maintenance from Tarun for the period till
She got married.
she got married, not more than that.
Yes, Your
So
Lordship.
far as child is concerned, child is entitled for the all benefits from
Tarun.
Tarun. His maintenance, that baby's maintenance,
Yes.
not Abha's
Abha's
maintenance.
maintenance. Okay.
Baby is entitled to
Get all the facilities because Tarun is the biological father of that baby.
yes, you must all have heard that even a illegitimate child,
Yes.
even a illegitimate child
child.
is there. So that child is entitled for every facility, every benefit, every entitlement, every right from his biological father. Right? So Abha's petition is partially allowed by all three. Partially
Your
means
Lordship,
that the maintenance will be till the date she got remarried and she got married, and she will be entitled to have maintenance for the child, which was a result of her relationship with Tarun. Right?
Yes.
Mr. Counsel, in subclause 4 of section 125
Yes.
itself, there is a statute. There is only one exception in section 125.
Yes, sir.
There is only one exception in section 125. In case wife is in adulterous relation with somebody,
Then she will not
only then she would not be entitled for maintenance. But here, in case of Hava, she was not only in adulterous relationship, rather she got married with
Somebody
Sushant,
else.
right? So she is not entitled to get maintenance from Tarun for all time to come.
Or
She is only entitled for the period
till
she
got
lived
married.
with,
Till she got married.
she got married, right?
Indeed, your lordship.
So actually, I have got experience of these moot courts, and sometime I ask that these parties and facts were given by your choice or by choice of the faculty or moot court society. So I came to know that it is given by the moot court society. It's like a lucky draw. Anybody can be appearing on any side, right?
Yes.
So it's not a case of that one is winning or one is not winning. It is a case of facts. So under this situation, Abha's
Is entitled to get.
Abha petition is also allowed partially. So your both petitions are being allowed.
Much
But Abha's
obliged, your
petition is
lordship.
being allowed partially, and you should be happy to know that you are not going to pay maintenance for all time to come, right?
Much obliged.
So you should also be happy.
Much obliged.
Both parties should be happy,
Much obliged.
right? So she wanted to give a clapping. I'm not allowing her. The reason is that in case she will develop this habit in actual court, we can't clap. So the moment we'll clap, in case I am also sitting in the court, then the judge will ask, Murari Tiwari, इधर आइए, आपने कैसे कैसे वकीलों को लाइसेंस दे दिया बार काउंसिल से? ये बैठ के ताली बजा रहे हैं कोर्ट में. They will not ask her. They will ask me. So Prabha madam has also come. Good. चलो, तो ये हो गया issue हमारा settled. Now we should come on the third.
Issue number. Sir, that would be presenting by my co-counsel.
अच्छा, what is that? Come. What's your good name?
Ahuti.
Ahuti. So what is the issue now?
The issue is whether the appeal filed by Sushant against the decision of District Court of Dekapur, in which the petition of Abha for maintenance in separate residence was by District Court of Dekapur, is maintainable or not. It is respectfully claimed that the respondent's concealment of substantial fact concerning her premarital pregnancy from another man renders this marriage voidable on 2 counts. 1. Concealment of the truth. 2. Premarital pregnancy from another man and not the petitioner. To be read with section 12(1)(c) and 12(1)(d) of Hindu Marriage Act 1955. Hindu. (12)(1)(c), that the consent of the petitioner, or where the consent of the guardian in the marriage of the petitioner, the consent of such guardian was obtained by force or by fraud as to the nature of the ceremony or as to any material fact or circumstance concerning the respondent. 12(1)(d), that the respondent was at the time of the marriage pregnant by some other man than the petitioner.
Have you filed a petition for amendment?
Pardon? The council seeks permission to continue. Indeed, your lordship. Here it would be applicable to mention section 114 of Indian Evidence Act 1872, which states the court may presume existence of certain facts which it thinks is likely to have happened, regard of being had to be the common course of natural event, human conduct, and public and private business, in relation to the fact of the particular case. It is further stated that as to what is common course of natural events, human conduct, and public and private business, depends upon the common sense of the judge acquired from experience of worldly and human affairs, tradition or convention. In the leading case of Savita Behen Sombhai versus Bhatia versus State of Gujarat, the court may please refer to the page number 22 on the memorial. The Honorable Court, Supreme Court has held that Section 125 of the Code of Criminal Procedure has been enacted in the interest of a wife and one who wants to take the benefit under subsection 1 of Section 125 has to be established that she is the wife of the person concerned. The issue can be decided only by reference to the law applicable to the parties. It is only when such relationship with reference to personal law is established that an application for maintenance can be maintained. The issue whether 125 is attracted or not can be answered except by reference to the appropriate law governing the parties. The concealment of material facts. Marriage would only be considered valid if the proper facts and issues which can be raised in the marriage and can create a dispute are clearly cleared beforehand. Section 12(1)(c) of Hindu Marriage Act clearly states that if party is major, it is required to make himself aware of all the facts concerning the respondent and not guardian, as he has already gained his majority. The material facts were withheld from the appellant with the sole intention of cheating on the appellant, has evidenced by the fact that when appellant and respondent were on a pre-wedding tour where Tarun showed up his presence, respondent introduced him, Tarun, to the appellant as a friend. Tarun had clearly arrived to see the respondent, demonstrating that respondent has withheld information concerning pregnancy with Tarun. The appellant provided his consent without being aware of this reality, and if the consent is not free from misrepresentation, the contract to marriage will not be upheld, rendering this marriage voidable under 12(1)(c) of Hindu Marriage Act 1955. Lastly, in the case of Harvinder Kaur versus Harmander Singh Chaudhary, it was held that marriage the court may please refer to the page where it is flagged and the lines are highlighted. The marriage is a contract of the greatest importance in civil institution, and it is charged with a vast variety of rights and obligations. Right of property are attached to it. The essence of matrimony is consent.
We understood. It's okay. Now you are representing
Yeah, I'm representing
Abha.
Abha and
It's second case against Sushant.
against Sushant.
You are saying that Sushant is liable to pay the maintenance
Yes,
to Abha.
of course.
So I believe, let him argue his case. Now you start.
Indeed, your lordship.
You know what issue she has
Yes,
raised?
yes,
Eh?
yes, sir. Yes,
She
sir.
has, shake the foundation of your marriage.
Yes, sir.
So now you have to
Of course.
keep it in mind that what you have to say.
Yeah, of course, sir. Of course. Thank you, lordships. The first of all, my co-counsel mentioned that there has been concealment of facts by Abha from Sushant that Abha has been pregnant. Now, this is incorrect. I draw your kind attention towards the proposition which is mentioned on page 10, para 3 of our memorial, which I read for the ready reference of all of us. After discussion the entire situation truthfully. I repeat, truthfully. Sushant's father accepted the proposal for marriage. Clearly, everything was in knowledge of the Sushant's family. The festivities began in both the families. A pre-wedding tour was planned for Sushant and Abha so that they can understand each other very well. Number 1 point. Number 2 point. In the living relationship, Abha got pregnant. You will come to know of your pregnancy in 2 to 3 months. After that, your body starts changing. The bump starts showing. It takes some time. It has taken some time before the marriage was fixed. They went to Kasoli for a pre-marriage tour. The marriage happened on 14th January and things like that. So the body changes were very clearly applicable. This is a hidden fact, of course, not given in the proposition, but by inference, it is very clear that all the body changes would be clearly known to the Sushant and the entire family of Sushant. So it is not that any facts were concealed. If you go to the 12D, which my co-counsel has very rightly proposed, and if you see the provisions therein, provisions say that even after knowing that the wife is pregnant, and if you cohabit with her, you have accepted the fact. And 12D. Sir, shall I read, sir?
12D.
Yeah, 12D.
No marriage, section 12D.
Yeah, D, yes, sir. If you see not the class 2 north with standing. Number 2 and number
Yes, subclass 2, there is
2, and then B subclass 3.
Okay.
So it's very clear that the intercourse, if takes place with the discovery, then this cannot be a voidable marriage. And voidable marriage is also at the instance of the person.
Your only issue is that she is not entitled for maintenance.
Sir, I'm
Yes.
from our side, I'm saying that she is entitled.
You are from the other side, she is entitled for the maintenance.
Yes, sir.
So you are talking about voidable marriage.
Yeah, so she had not concealed any fact.
No, admittedly, there is no petition for declaring the marriage as a
Absolutely.
null and void, right?
Absolutely, sir,
So no
absolutely.
petition is there.
No petition is
So why
there.
you are unnecessary raising that
Absolutely.
issue?
And that is also based on incorrect fact because everything was in their knowledge.
In case there is no petition for getting marriage declared as null and void.
Null and void.
So the assumption and presumption is that this relationship has been duly accepted.
Yes, sir.
So he cannot run away
Absolutely.
from his
Knowledge.
liability.
Knowledge and
From his
liability.
liability of maintenance.
Yes, sir. Yes,
Right?
sir.
You
Yes,
want
sir.
to say like this.
Absolutely, sir.
So
And-
the argument is baseless.
Yeah. the
You
argument
are
is-
saying that everything was disclosed to her, even though
Absolutely.
she was pregnant.
Yeah.
In case it was disclosed,
Yeah.
then it is not an offense. It is not a concealment. It
Yeah.
cannot be declared as null and void.
Yes, sir.
Even in case she was having relationship with somebody else and it was disclosed at the time of the marriage.
Yeah.
It is not a
Yeah.
case of fraud or it's
Fraud.
not a case of voidable
It
marriage.
was told and he continued with cohabitation also.
So now this issue will require rebuttal.
Sir,
So very precisely, he has put his claim, right? She is entitled for maintenance, madam. So get ready for rebuttal. Now rebuttal requires. I want to convey you all that where is the requirement of the rebuttal. He has rightly put his case that it is a maintenance petition. Till date, you have not filed any petition for
voidable marriage.
annulment, and everything was disclosed to you. And you were having all knowledge that I am already pregnant. You are aware that I was having relationship with one Tarun. You are aware about everything. So you considered, rather you considered it and now you are running away.
In fact, sir.
Okay.
In fact, sir, one of the incident mentioned here is that Sushant's mother discovered on telephone.
Huh?
Another incident mentioned in the proposition is that Sushant mother discovered on Abha's telephone her frequent telephone calls to Tarun.
We got it. In case it is disclosed before marriage, then it cannot be a ground for annulment, right?
Yeah.
It cannot be a ground for
Yes.
denying the maintenance.
Absolutely.
Right. So now it requires rebuttal from learned counsel. Let us see. She is also addressing very good argument. So get ready. What is your argument?
There, in the mood problem and in the fact it is clearly stated that after discussing the entire situation truthfully to Sushant's father, not Sushant himself, and I repeat, I have already mentioned that in 12(1)(c) of Hindu Marriage Act, it is clearly stated that if the husband is of majority, if he has the majority age and if he is of a sound mind, then this fact should be clear to him, and the whether the consent of the parents is or is not required.
He is saying that, look, there was already she has already conceived, right? Abha had already conceived, but it was communicated to you. Therefore, you had not filed any petition for annulment. There is a provision in section 12 of Hindu Marriage Act, which you are referring. These marriages are voidable marriages. So admittedly, you have not filed any petition getting declared this marriage is a void marriage, right? Have you filed any petition in this moot problem, whether it is mentioned there that you have filed any petition
The
for?
council is afraid they have not.
They have not filed, right? So admittedly, you are aware about all these things.
But
So it may
practically-
go against you. Every time you can't win. You are bound to pay maintenance to Abha, right?
But the council practically, if it can be seen, then the pregnancy can be hidden as with a shawl, or can be stated that Abha was physically healthy, that is, she was fat with her healthy body.
This is lot of presumptions, sir.
So actually now she is developing the moot problem also. She has come to know that how it could have been drafted. I appreciate.
It was
I
just,
appreciate, I
it was
really
just
appreciate
for-
your argument. But you have to understand that in case in your practical wakalat, in case you find any such brief, so the moment you get anything to make a claim, you do that. In case this problem comes to you in reality, so don't get afraid of filing a petition which is required under the situation, right? So it was a favorable point for the husband. In case these are the facts, he could have gone for a petition for annulment of the marriage. But Mr. Counsel is very happy because you have not filed it. You have considered it. So you have to pay the maintenance.
the council, it was clearly mentioned to Sushant's father, but not Sushant himself. The husband himself was not aware about it, but
Okay.
the parents
We
were.
understood because, in Hindu Marriage Act, you must all be clear that no third party is allowed in their relationship. In case you have any grievances, then only either husband or wife. Father cannot come into picture that it was communicated to my father and all.
Father. Exactly.
You yourself have not filed any petition. So you cannot shift the onus on your dad, right? So this case, we are sorry, you are losing on facts and law. What do you say?
Yes.
So the Abha's counsel is smiling. Okay, arguments we have already heard. And one more fact I must share with you all, that the marking will be given by my two brother colleagues only. Then you will ask that why I don't give marks, why I don't decide. I never wanted to be a judge. I joined bar in 1991. My all classmates who were interested to be a judge, they have become judge. They are already session judge, district judge, high court judges. They are getting elected also directly, but I'm not interested. Reason is the giving decision is very difficult. And you all will join bar council. I am there to get you enrolled as a lawyer, and I'm in habit of contesting that election also. So in case I will disappoint any of you, then it will be difficult for me that Mr. Murari Tiwari ने मेरे खिलाफ decision दिया है. So मैं देख लूंगी और मैं देख लूंगा. So you must be clear that today's marking will be given by my both brothers. They are not in bar politics till date, I believe. You fought, but you cannot be directly affected by them. But I am directly affected by them because everybody will compulsorily will join bar council. They'll come for enrollment. I think in 2022 one batch is coming from this university also. So Mr. Asthana told me that one batch is coming. So I am there to welcome you all, right? So, but I will not give the marks. Whenever you get the result, you blame either of them, not to me, right? So that is disclosure by me. You must be aware about it. But you both the sides have argued well, presented your case very perfectly. The purpose of this moot court system was introduced by Bar Council only, with the reason that you should get some idea. It's a professional course, right? Before coming to court, you must have basic knowledge that how things are presented in court. We allowed internship also. In my time, when I was pursuing my law from Campus Law Center, Delhi University, that was this internship was not there. We were quite anxious to see the courts, but we got chance only after completion of our law graduation. But now we have got it introduced. The thing which I suffered, I faced, I thought that when I'll be a office bearer in Bar Council, it will be introduced. So majority of you go to court also. The purpose of this moot court is that to break your hesitation, you should have an idea how to present your case. So what I try to convey you today, that be confined to your fact, be confined to your issues, right? Don't go in unnecessary pleadings and facts. There are certain things which are already admitted by the other side. So need not to elaborate that. You assume it that it is already admitted. Why to talk about that? So it was a very nice session. I enjoyed. Now my brother colleague, they will also say something. They will express their views. Please.
Hello, friends. It's a great honor for me to be here and judging this moot court. As I judged you, all these one of the teams during the semi-final round also. And so you people are doing exceptionally well. And it is a great opportunity to hone your skills as lawyers, because this is what you will be going to see in real courts. And more or less something like this. Yes, we don't have to laugh and we don't have to make faces, because the judges take it, sometimes they feel bad and they object to it. So we have to be very, very sincere and while presenting our case. And as sir said, like to be a successful lawyer, I think you need to prepare your brief thoroughly. Your weapon is, the weapon of lawyer is the case laws, the precedents set by the courts. Yes. So to prove your case, to make your case foolproof, you do a lot of good research so as to bring home your point across the bar, across the bench. So all the best to you, to both the teams. Thank you for making me a part.
Much obliged, Your Lordship.
They will announce the result at later stage. So now my brother will also share.
I just want to ask whether are you willing to settle the matter with them? He's already declared result. He will not settle now.
It will be much extended if we do so.
Then this complex kind of dispute, that's the best way possible. Now,
It is.
sitting as judges, now I'm understanding how difficult is it to judge.
So my brother, what he want to convey is that mediation and conciliation process is equally important in courts. So he wanted to convey that whether you both councils will also share the memento or but anyway, good luck, good wishes. But I'm again making it clear that I'm not a party to this issue. Be clear, right? So no grievances against me. Anyway, thank you, good luck, good wishes.
Sir, I would like to say something.
Yes, why not?
Sir, even though if I lose or I win, it does not matter. I learned is what matters. And you giving point, or if you had given us point and if you did not have given us much points, then we would have learned from it that we have much more to learn and we would not have felt bad.
Thank you. Good luck, good wishes.
Thank you, sir.
Okay. You know, I wanted to share one thing. Just wait, Mr. Council, आप भी बैठ जाएं. बैठी. You know what it requires? It requires now this moot is over, right? I'm talking something other than the moot. I'm talking about the professional commitment which you would require in future. Today, a minor surgery was to be done to my wife. Time was scheduled as 9 o'clock, but it was shifted to 1:30, right? So here, my name was already circulated long back, and Mr. Asthana, I had to answer him. Prabha ne bhi bahut request kiya tha. She was being operated there, and I was bound to be here. So this kind of commitment is required in future. In case here 500 students or 300 students are enrolled and hardly 60 or 70 or 100 are here. So the students who are present here, it shows their intent that really they are interested to do something in this profession. And the rest 225 or 150 who are not present today, they must be enjoying somewhere in CCD or anywhere, wherever they are. They will tomorrow, you know, start accusing you that how you people have erosion like this, how you are doing better. So you have to keep it in mind that your hard work will pay in future. Don't accuse this profession that wakalat kuch nahi hoti. Wakalat is everything. Do you know that the first citizen of India, he was also practicing with us in Delhi courts only. He is the Honorable President of India. Not the present one. I'm talking about everyone from the first one, from Dr. Rajendra Prasad. So you should know the legacy of your profession which you are going to join, but subject to your hard work, your dedication. Murari Tiwari started his career with zero background, achieved everything. There are many friends who have achieved more than me also. Sometimes I admire them because they must have been doing something better than me. So what I want to convey as a student, that you have to put your hard work. Don't depend on your faculty. Don't accuse. Majority of you say that my faculty doesn't teach me. There are no classes and all. For learning this law, you need simply IQ. You have to understand it. Lot of illustrations are given. I was very happy to look into 12.1, 12 A, B, C, D, right? Then the second clause as well, my brother pointed out. So you have to learn it. You have to develop it. Unless you are not aware about the laws, you cannot develop your facts. The client will come to you. They will tell their problem to you. You have to convert into a story. You would be a story writer, but unless you are not aware about the supporting law, you will not be able to write your story in a proper direction. It is simply writing a story. But you know, majority of you are not present here, I can assume. But you can notice, you can convey them that you are loser. You are loser today. Right? So that is more important. So we cannot accuse every time our faculty that they are not teaching us. We have to study at our own. Right? Good wishes for your career. और कोई भी प्रॉब्लम कहीं बार में काउंसिल में जीरो से भी स्टार्ट किया तो भी कोई सीनियर चाहिए, कोई परेशानी है, कोई प्रॉब्लम है, कोई बीमारी है, उसके लिए मैं हूँ, तुम्हें कोई जरूरत नहीं है. तिवारी मुरारी, मुरारी तिवारी में से कुछ भी याद रहेगा। ठीक है, थैंक यू वेरी मच। मैडम क्या आदेश है?
हेलो हेलो, हाँ कौन? अच्छा तो ठीक है फिर। Oh my God. यार बढ़िया था। अभी डिसाइडेड टू वॉलिंग अरे यार ट्रॉफी हमारी है, 3 ट्रॉफी लाके रखना है बस यार। मैंने कभी 5100 से नीचे मैंने सोचा ही नहीं। 5100 तो 5100।